Thank you very much, Chairman. Professor Amar, welcome. You say in your written testimony, and I'm quoting here, the power to pardon subsumes the lesser power to decline prosecution for any number of reasons. Can this lesser power you describe be regularized by the President into policy so that the folks who are actually enforcing the laws have a specific direction from the President as to that lesser power to decline prosecution?
Yes, and it's typically subject to revision. So, for example, President Obama could basically say, we're not going to pardon people who violate, arguably, federal laws in Colorado on possession of marijuana.
So it's subject to revision, but
yes.
It's not unconstitutional for a president to say we're not going to prosecute, for instance, the DACA kids.
And DACA is a little trickier because it's not on the criminal side fully. Some of that is civil non-enforcement, but yes.
But the power of the president
for criminal,
in that respect.
Excuse me?
The power to choose to enforce is equally executive in either case.
Yes, but with criminal, it interacts with the pardon power in a way that it doesn't on the civil side. To put otherwise, you can have, for example, private prosecution on the civil side, antitrust laws and the like, and you can't have that on the criminal side. So there's more power of non-prosecution on the criminal side.
So, first of all, Professor Posner, welcome. Do I understand that you're the son of Judge Posner?
I am, yes.
Let me tell you, I think it's a great loss for the judiciary that he retired. He had an extraordinarily distinguished career, and I think was one of the historic judges. So pass on my compliments.
I will.
I have three questions that I'm not going to ask you all to answer right now. As the chairman has said, you have the ability to reflect on these things and then answer as questions for the record. But I'd like you to reflect on three things. The first is, it's been said in this hearing that the president can't order an official to do something illegal. Does that mean that it is unlawful for the president to order an official to do something illegal? And if it is unlawful to order an official to do something illegal, is there a remedy, a legal remedy for that? And obviously the context here would be that the firing of the special prosecutor would in fact be an act of obstruction of justice. So that's question one. Question two, there is a certain amount of debate over the role of grand juries. I don't think anybody's testimony here has touched on the role of grand juries. But there is at least an open question whether the grand jury is the instrument of the prosecutor or whether the prosecutor is the instrument of the grand jury. As I understand it, once a grand jury is sitting, the grand jury has the ability to tell a prosecutor to go pound sand, and they're not going to give them subpoenas. They have the ability to demand subpoenas and witnesses even if the prosecutor doesn't want to produce those subpoenas and witnesses. The U.S. Attorney's Manual describes the grand jury as an independent body of government. So how does the prosecutor, in his role, potentially as the servant of a grand jury, engage in this whole separation of powers question? It's a little bit of an interesting wrinkle that I think we should not overlook. We're doing a great job in this country right now of overlooking the constitutional role of juries and grand juries. Our founding fathers, I think, would be stunned and horrified. And I think that puts an extra, at least a wrinkle into this analysis. Once you have a prosecutor who is now the servant or the instrument of a grand jury, does that affect in any way the ability of the purity of an executive authority to terminate? The third is the 25th Amendment, Section 4, which says that the vice president and a majority of the principal officers of the executive departments can actually remove all executive powers from the president. They can, at least temporarily, displace him from office. So if the Vice President and a majority of the principal officers of the executive department have the power to remove all powers from the President, would it not be at least logical to presume that a similar body, consisting of the Vice President and a majority of the principal officers of the executive department, have to sign off on the firing of special counsel? Would it be closer to the constitutional scheme if you avoided the judiciary entirely and established that that same panel that is already in place under the 25th Amendment had a voice in this decision, and that the lesser power to say to the President, hold off there, you can't fire this guy while he's investigating you, is subsumed within the greater power of removing all powers from the chief executive? Those are complicated questions, and I look forward to your responses in due course. And I appreciate the erudition and expertise of this panel, and I thank the chairman.
Senator